We're very thankful to Jongbaek Park, who's also logged on, uh, senior partner at Bae Lee and longtime ICCK board member, who was obviously very instrumental in arranging this. We come to you live from the offices of Bae Lee and many other places. And you can see our two speakers ready to join us. We've got Elizabeth Yu, first of all, and she'll be talking about, but before I talk about that, I should say that overall, and before I make the introduction, I'd like to just make one broad comment. Overall, we know that the risks to a CEO are great in Korea. And it would seem over the course of time, the risks increase rather than decrease. It's a dangerous country to be a president, whether you're the president of Korea or you're the president of a company. And hence the need for good lawyers, good experienced lawyers, which we've got ready for you today. So Elizabeth Yu will first be talking about key aspects of the Serious Accident Punishment Act and in comparison with existing occupational health and safety liabilities. And then second, Hyun Kim will talk about recent major developments in environmental regulations. Now, I'll introduce Hyun Kim as soon as it's her turn to speak. And first, we'll just briefly introduce Elizabeth and then turn the mic over to her. I'm not going to do the extensive intro or bio narrative that was given with the flyer, but rather I'll just say a few things. Elizabeth went to got her law degree from the University of Florida a long time ago. She was admitted to the bar in Florida in 2001. I had the privilege of working at the same firm as her for a number of years. There was some overlap. We were both at Kim and Chong, and we both find ourselves elsewhere now. So she was at Kim and Chong for 16 years, and then went in-house for a couple of years, where she was the regional counsel for applied materials. And then after that, joined Bae Lee, and you've been there at Bae Lee for going on 2 years now. Elizabeth is well known in Korea with over 20 years experience. Obviously, her specialty is employment and labor, but that is not the end of her specialization. She has in-depth experience in corporate restructuring, compliance, anti-corruption, corporate governance issues, and many other things. So with that, I'd like to turn the mic over to Elizabeth, and then after you're done, I understand that what we've decided to do is hold the Q&A until the end, right? And then we'll have a joint Q&A after both sessions. But with that in mind, if you have an urgent burning question throughout, I think no one would object to potentially addressing those questions, if Elizabeth is okay with it. But the basic format would be questions afterwards. Elizabeth, we turn the mic over to you. Thank you.
Okay, thank you, Jeremy. As you mentioned, I prefer interactions. So if you have questions, please feel free to ask them if you're comfortable asking them, as opposed to saving them to the end, so that it won't be just, boring me dragging on for 30 minutes or so. But technically, I am supposed to be introducing you for the first 30 minutes or so on the key aspects of the Serious Accident Punishment Act. So as Jeremy mentioned, I do have quite a bit of experience in Korea. I'm not that old, Jeremy, by the way. You mentioned I was old, been in this industry quite a while, but I'm not that old. But 20 plus years of experience is not going to help me much, because this law is literally just off the books, right? And in fact, the regulations underneath it have yet to still be officially announced yet. Even though we do have a draft, we have, the underlying decrees and the regulations that are still going to be coming. And like I said, this law is very new, so we're all going to be learning it together. But hopefully, my 20 years of experience doing employment and labor, especially since we're comparing it to OSHA, which is quite an older law, much more expansive law, that I'll be able to do a comparison for you that will be helpful for you to understand, exactly as Jeremy mentioned, what your liabilities might be for those of you who are CEOs or top executives of organizations. Okay, so like I said, about 30 minutes. Bear with me. If you have any questions, feel free to chime in. But with that, let's get started. The things that I want to cover with you in the next 30 minutes or so is, first of all, the implications of an industrial accident. Okay, So when we talk about industrial accidents, we're talking about basically workplace accidents. So it's a big word, industrial accidents, but it just basically means accidents that happen at the workplace, whether it's somebody dying or somebody getting an illness, somebody getting injured, okay? So we want to talk about what is the implication once an accident or an injury occurs at the workplace. And then we're going to talk a little bit about the legislative background and why that's relevant for you to understand the new law, SAFA, Serious Accidents. It's a mouthful, Serious Accident Punishment Act, and we're calling that SAFA for short. And why that's relevant, especially given the fact that, as I explained, we're going to be comparing it to OSHA, Occupational Safety and Health Act, right? And why, even though we already have a framework, we needed this other law. So I'm going to give you a little bit of legislative background on that. And then obviously the main part is going to be the key provisions of SAFA and the distinction with OSHA so that you understand what the new law says and what your obligations are there under. And then, of course, I don't want you to walk away from here thinking, okay, now I got a legal course under my belt. I want you to walk away understanding, okay, now that you understand what the new laws are, what should you, as somebody in the organization, need to pay attention to, do differently in order to be compliant and to look forward to those issues that the new law is going to be addressing, okay? So those are the topics I want to cover with you. So starting with the implications of the industrial accident. So when there is an industrial accident, what is it that you should be concerned about? The three big things that you need to be, I guess, anticipating. One is obviously the legal process, right? So the criminal investigation and prosecution. Obviously also business interruption, because you guys are, unless there's some of you out there who are in nonprofit organization, we're assuming for your organization, you're in it to do a certain business. And if there's an occupational accident in your workplace, there will be potentially a business interruption to that business, okay? So that's something you need to be aware of. And then obviously the reputational risk, even though it's not a direct interruption to your business, it can, as most of you may have experienced already, especially with the advent of social media and whatnot, reputational risk occurring due to an industrial accident is not small. Again, with a lot of the activity going on social media, okay? So specifically going back to criminal investigations and prosecutions. Oh, by the way, I do have a tendency to talk quite fast. So if anybody gets lost or wants me to slow down, please raise your hand and let me know, and I will try to go slower. But that is my tendency to talk a bit fast. So I apologize for that in advance. So going back, criminal investigation and prosecutions. When there's an accident in your workplace, you're going to be thinking, okay, somebody's going to have to come and investigate that. And specifically with regard to industrial accidents, it's not just the police coming out and do investigations. It will also be the labor investigation, the labor investigators, okay? And the reason for that is in Korea, while the police have jurisdiction over certain criminal activities, so specifically under SAFA, which will have criminal implications, that's why you will have police out there investigating that aspect of the accident. But also the labor investigation, the labor investigator will be out there as well, because they're responsible for investigating crimes specifically under OSHA, okay? So even though we have this new law for SAFA, it does not mean OSHA doesn't exist. Those laws go hand in hand together. And so because of that, you have the labor investigators out there investigating aspects that will relate to OSHA potential violations. And you also will have police out there because now under SAFA, again, criminal liability potential, as well as any other sort of, criminal liability that might be applicable. So you have that dual sort of investigation going at the same time. What does that mean in terms of your, the top management people that might be subject to the investigation? While those investigations are pending, those people who are key to the investigation might have, for example, an exit ban. So that's something you're going to need to take into consideration as you're handling the matter, because you're going to have to manage, okay, are we going to have to, rearrange schedules, rearrange certain, what certain people can do, because during the while the investigation is pending, you might have limited movement, and you'll need to be available, for example, for interviewing or any questioning that the legal officials might have. So those are things that you'll have to take into consideration, as well as not just for your top management, but anybody else who might be a witness, who might be a deemed suspect. And also in the worst case scenarios, you might have investigators come to your workplace and want to, take documentation or take evidence they think is relevant. So we would normally see that as a dawn raid, where they would come and without notice take things from your workplace possibly that they will need for their investigation. So those are sort of the things that will be ongoing as soon as an industrial accident happens. God forbid something as serious as someone dying, then obviously the level of those investigations that are ongoing and the activities that go along with that investigation is going to be that much more. Okay, so that's one thing that you're going to have to worry about, is that investigation. But as I mentioned, as that's pending, what do you do about your business? Because again, depending on the situation, let's say there was an accident, there might be a potential for either that specific location of the accident, or something broader like the entire work site being cordoned off so that you can't continue work while this is pending. So that's something you're going to have to work through with the officials that are investigating, possibly, to try to minimize that impact to your business as much as possible. But that is a possibility, where for a certain period of time, a certain area or the entire workplace might be cordoned off while the investigation is pending. Okay, and obviously, our effort would be to try to make that suspended period as short as possible. But that's something for you to take into consideration in terms of how do we manage our workload so that we can continue to meet our contractual obligations to our suppliers or to our customers while this investigation is pending. Okay, and then the last thing, obviously, that's on this chart is the reputational risk. Aside from, again, the direct business interruption impact, you might have negative attention to the company, especially again in this day and age of social media. That will also not only have potential implication in terms of marketing or just name recognition of your brand, but also the impact it might have to the government investigation that will be ongoing, as I mentioned already. Okay, so in case there's an industrial accident in the workplace, those are sort of the key things that's going to be ongoing, things that you're going to be having to deal with as an after fact of the industrial accident. Okay. We're going to move on to. Oh, I'm sorry. Go ahead. Fair question. Okay. Maybe that was just. Oh, we can use that. So that was just my voice. I think I'm going to try to ignore that. All right. So moving on to the legislative background. So as I mentioned at the very beginning, we have this new law, SAFA, and then we also have the existing law, OSHA. And some of you might be thinking, well, if Occupational Health and Safety Act already covers industrial accident issues, why do we need this other, act to cover the same thing? This is a statistics that was just released for the year 2020 from the Ministry of Employment and Labor. And as you'll see, in 2020, it recognized 882 occupational deaths. So people who died during the course of work. And as you can see, luckily, the trend is going down, where there's less cases of occupational death. But what this chart doesn't show you is, well, actually, before I get to what it doesn't show you, just want to give you a little bit more color into who is impacted by the occupational death. So, which probably won't come as a shock, but the majority of deaths occur in the construction industry, as well as followed by the manufacturing industry. So those of you on the call today who are obviously in those industries, this topic is going to be particularly important to you. But even if you're not in those industries, and even if you're not dealing with deaths, this law, as we'll discuss shortly, is not concerned just about people dying, but also, again, illnesses and injuries. And according to the statistics that came out, overall, workers' compensation claims last year increased quite significantly. So as you'll see, again, not just worried about deaths and not just in the construction industry or the manufacturing industry. So those of you, who are on the call again today that are not in those industries, you should still pay attention because you may still have liability in terms of illnesses. So you'll have to think about, do we have, how much workers' compensation claims do we have in the company, and involving what kind of illnesses or accidents, okay? So again, going back briefly on sort of the legislative background, you see that there was this sort of public demand that resulted in the government, the whole of government, not just the administrative side, but the judiciary as well as the legislative side, coming together to try to make improvements. Because for those of you, again, who've been in the country for the last, I don't know, at least 5 or 10 years, you're probably aware of a lot of stories that were in the news regarding a lot of accidents that might not necessarily be just about work compensation, so meaning not just workplace accidents, but also sorry, we're getting feedback and it's a little bit distracting. One major accident that was in the news quite a bit. It's already been, oh my goodness, it's already been 6-7 years, I believe. So if you were here back then, you might be aware of what was called the Seodo ferry accident. So massive accident that involved, I want to say 300, 400 people. I think it was 400 more, almost 500 people on the ship, but 300, 400 people who died from that accident. And even though, you know, lots of attempts were taken in order to find people liable for that accident, it wasn't, I guess, satisfactory to the people, to the public that were involved. So that was a lot of outcry regarding that accident. Similar accidents like that, but also involving, you know, workplace. Most recently, I think there was one, I want to say in 2020, early 2020, where there was a fire and for a warehouse construction. And I think like 30 people, 40 people died in that accident. So again, those kind of accidents have resulted in sort of an outcry by the public, not just the employees that were involved, but especially like in the Seodo ferry accident where it was the public that was involved, that people really wanted accountability, somebody to be held responsible for those actions that current laws weren't able to catch. And so you have that sort of background that led up to this new law, SAFA, that was just passed in January of 2021, so this year, and also continuous updates. In fact, massive updates to the Occupational Safety and Health Act that also took place earlier this year, but actually happens quite frequently, especially in the past several years. And in fact, we have several updates that will be going into effect even later on this year. So we have sort of from the legislative perspective, we have updates in the laws to try to but you know, hold people accountable for those accidents that's causing an outcry in the general public. But on top of that, not just from the legislative perspective, but also the judiciary is paying attention to what's going on in the public. And what they're doing is when actions come before them, they're taking into consideration sort of this public outcry in terms of when they render the punishment, as opposed to, for example, in a lot of the laws, it will say sort of the max. So you can, you know, let's say 3 years, 5 years, 10 years imprisonment, or 30,000, 50,000 Korean won in punishment. And from the judiciary's perspective, rather than maybe going on the lower side, they're looking at imposing the harsher end of those sanctions. Okay, so that's sort of the judiciary's approach and what they can do to sort of respond to the public outcry. And then obviously from the administrative perspective, you have government wanting to reflect what they actually want to see reflected in corporations. So as we'll talk about further on, one of the things that you might want to consider for your organization is making sure you have an organizational structure that will attend to specifically health and safety issues. That's what this law is actually intending, to make sure that you have that kind of organization in place. And so to reflect that, what the government is doing is, if you're familiar with the Ministry of Employment and Labor, you have the Ministry of Employment and Labor up top. You have the Vice Minister. You have 3 major offices. So for example, I think it's called Planning and Coordination, Employment Policy, and Labor Policy. Those are the 3 big offices under the Ministry of Employment and Labor. And then below that, you have a whole bunch of bureaus that handle, you know, more specific aspects of employment law, Occupational Safety and Health Act, things like that. And again, currently, industrial accident prevention and compensation is a small bureau underneath the Labor Policy Office. And because the government wants to give more focus, give more authority, give more attention to this issue of occupational accidents, they're thinking of raising that up into an office level. so that they will have, again, more authority, more possibly funding, more attention anyway, being paid to those kind of issues. And that reflects what they want to see companies do within their organization. Okay, so that's what you're going to see reflected in some of the comments that we talk about in the suggested measures. So that is the legislative background. But one last thing before we move on from the legislative background is wanted to read for you the specific objective. So for a serious industrial accident or a serious public accident, because as we mentioned, SAFA is not just dealing with industrial accidents, but also public accidents. The Act aims to secure safety of employees and general public and to prevent occurrence of serious accidents arising from failure of corporate organization or lack of advanced safety management by imposing criminal penalties on, and for those of you who are listening, this will be the key part, business owners, CEOs, and corporations. Okay, so we're going to break this down as we go into the specific of SAFA, but basically, you know, SAFA is not worried so much about who didn't put out the cone that caused the accident, who didn't, you know, use safety goggles. They're not that much into the details. They want to know, why was there no safety goggles? Why, you know, did we not provide funding so that people had proper safety goggles? Or did we not have manpower out there who should have been telling people that they need to wear safety goggles? So manpower and funding. And those are not things at the bottom, but those are things that further up the top, your CEOs and, you know, the corporation as a whole, they should be addressing, is the approach that SAFA is taking. And because that is a failure of the corporate structure, they want to hold people at the top of that corporate structure responsible. That's something you're going to hear me reiterate over and over again, how this is different than Occupational Safety and Health Act, OSHA, because usually for OSHA, you will have people who are more hands-on, people who are lower down the management chain, that's usually held responsible, as opposed to SAFA, where you're going to start pretty much at the top and then possibly go down. But the main objective is because they see it as a corporate structural failure that caused the occupational accident, as opposed to, you know, a very specific thing or a prevention that could have occurred, that they're starting at the top for liability. Okay, so that's a very important legislative, you know, objective that I want you guys to, if you get nothing else from this presentation, is to walk away with the gravity that this law is trying to impose at the top, as opposed to further down the chain of command. Okay, so let's get specifically into the actual provisions. Before I guess we get into that, I wanted to let you know just some details. So the law was enacted in January 8th of 2021, so earlier this year, as I mentioned. It doesn't go into effect for a year after it was promulgated. So in fact, it wasn't promulgated until a few weeks later. So January 26th, 2021 was when it was promulgated. So it will officially go into effect as of January 27, 2022, but it only takes effect for employees who are companies that have 50 or more employees, as opposed to people who have less than 50, but more than 5. That will take effect 3 years from now, so in 2024. Okay, those are some details. Employers who have less than 5 employees, this law technically is not going to apply to you, although there is some concern about why small employers have been excluded. So, oh my goodness, I just noticed that we're well into 20 minutes, so I'm going to try to speed this up. All right, so overview of the key provisions of SAFA in and of themselves. As I mentioned, we're not just talking about industrial accidents. This law covers both industrial accidents and public accidents. Okay, so public accidents would be like things that impact transportation or products that companies put out. So even if you have a workplace where you don't think that it's prime for accidents, if you're putting out products that will impact a mass number of people, this law may still impact you. Okay. Another key aspect of this law that we're going to be talking about is the responsible management party. It's a key term for those of you who understand Korean. We're referring to the 경영 책임자. Okay, So 경영 책임자 is the responsible management party. That is key in this law, because those are the people, that is the party who will be held responsible under the law. And specifically under this law, it could be someone who is deemed the person authorized to represent and oversee the business, and or the person responsible for the safety and health of such business. So in English, it's a little bit hard to understand exactly what that means, but that's why we're going to, go into the detail of what responsible management party means. But for now, that's who we're focused on, is the party. And what is this party responsible for doing under this law? They're going to be responsible for specific duties. Okay, so you see 1 and 2. I'm not going to read it here for because of time. And then again, the main part in terms of overview is the increased penalty and damages that might be possible under SAFA that you wouldn't have seen before. So for example, I want to point out number 1 specifically, imprisonment of minimum 1 year. So most laws will specify, if you violate it, that maximum what the imprisonment possibility is, or maximum in terms of the fine. But in this case, if someone has died, SAFA specifically says, if you're responsible, then there's a minimum of 1 year imprisonment. Okay, so that's quite different than any of the other sort of employment labor related laws that you see in Korea. And also point 3 as well, punitive damages. It's rare to see punitive damages in Korea, although we are trending towards more legislation that includes certain punitive damages. But in the past, it has been quite rare. But this law specifically does include punitive damages. And again, that's to show you sort of the gravity with which the law is being considered. Okay. So really quickly on this one, it's an overview of, again, the comparison. We're focusing a lot on the industrial accident side of it because we're comparing it with OSHA, which only deals with industrial accidents. But in and of itself, also deal with public accidents, not just industrial accidents. Okay. And as I mentioned, for public accidents, you're gonna, the person who's being protected, the intended protectee is different, obviously, than under the industrial accidents, which is intended to cover workers, as opposed to users under the public accident side. Really important is the triggering events. So you'll see, as I mentioned before, death, even if it's just one person death, it will impact both, whether it's a serious accident, industrial accident, or a public accident. If anyone has died, SAFA might be implicated. But in terms of injuries and illnesses, you'll see the different criteria. So it's not just for one. You'll need at least 2 persons that have suffered or needed at least 6 months for recovery for SAFA to be triggered in case of an injury. And then you'll need 3 or more persons that have within 1 year period for work-related illnesses to trigger SAFA. Okay, and then you'll have similar, but more people under public accidents that will be implicated or that will trigger SAFA. Without those threshold numbers of injuries or illnesses, you won't trigger necessarily SAFA. Okay, but just for sake of time, I will think. I think one last point I guess I should mention is for the penalty, since that's important. I already talked about how the minimum is 1 year imprisonment if someone has died. It's not as severe. You'll see for illnesses and injuries, it goes back to the normal way of presenting the punishment, which is up to a certain amount, and in this case is up to 7 years, or a fine of up to 100 million in case of injuries or illnesses. And again, something a lot more severe than you will see under OSHA. So going back to originally, who is going to be the responsible management party that we want to be concerned about in this case? And for a lot of you out there who are listening, if you're a part of the top management of your organization, this is going to be important because it may implicate you basically. So on the left, you see a person authorized to represent and oversee the business. What does that mean? Everybody's understanding basically that definition to mean the top person. So in Korea, if you're a corporate organization, basically you'll be the representative director, but not necessarily, because the representative director on the corporate registry might be registered as that, but they might not actually be operating the business, especially if you're a foreign owned company where you have on the corporate registry a foreigner who's not locally here operating the business. So that's why the definition is as broad as it is, because it wants to capture actually the person who is responsible for that business. Okay, so usually you're talking about your CEO, your president, your country manager. It doesn't matter the title. It's whoever the person authorized to represent and oversee the business is. But the important part is in the or, because again, there was some confusion, or not so much confusion, but there was some debate as to whether it's an or an and. And at the end of the day, the legislation was written as an or. So it seems like, okay, maybe that person authorized to represent and oversee the business. So let's say your CEO, for example, can they delegate this to somebody else who will be the person responsible for the safety and health measures of such business? Okay. So according to this, given again the intent of the law, everybody's interpreting it, even if you can delegate it to someone who is the person responsible for the safety and health measure of such business, that person is likely going to have to be someone of an equivalent position, or at least having full authority for safety and health issues, like your CEO, like your country manager, like your president. Someone of equivalent level is what this law is looking for, okay? But technically, as currently written, you can possibly delegate authority as the CEO, president, country manager to someone who will be designated as the person responsible for the safety and health measure of the business. Again, as long as they have sort of the full authority to deal with safety and health issues of the organization and not just designated by name alone. Okay. Oh, sorry, I wanted to do more comparisons with OSHA, but I am fastly running out of time, so I'm going to try to get through at least the SAFA provisions so that you'll know what they are when we leave. So now that we've identified, who the responsible management party may be, what is that person supposed to do, right? So that's the next important part. Article 4 in the SAFA defines exactly what it is you are responsible for doing. The business owner or responsible management party will take the following measures to prevent any event harmful or hazardous to the safety and health of workers in place of business under their de facto control, operation, and management in consideration of the size and nature of their business. The reason why I wanted to read this out to you, there's a few things in here that's still, uncertain from an interpretation perspective. That last part, especially the size and nature of their business place. It's not specified anywhere how that will impact the decision in terms of who is responsible or if they're responsible at all. But as written, it looks like size and nature of your business might impact liability, right, under this act. So that's something to consider. And the other part is de facto control, operation, and management. So it's not just, specifically your employees only. It's workers possibly in a position where you have de facto control, operation, and management. So it's a much broader concept than just your employees, or even a broader concept than the OSHA, which covers your employees plus a certain number of subcontractors. So it's a much broader concept under SAFA, okay? And even further, it goes into 4 specific things under that broad sort of requirement for you to handle secure safety and health. It has 4 specific things that it wants you to do as the responsible management party. And even under these 4, I'll give you a chance to read it later, but you will, when you read this, you'll see, okay, I'm not sure exactly what these things are asking me to do, which is probably okay because it's supposed to be further specified by the presidential decree. And as I mentioned very early on, the presidential decree has not been released yet, so we don't know exactly what the details will be, but we do have a draft that the government has released, and we're under the expectation that it won't change dramatically. So if you take a look at that presidential decree draft, you will see a little bit more outline as to specifically what 1, 2, and 3, 4 means, okay? So when you are going through how to implement or how to address health and safety in your organization, you will definitely need to not just focus on these 4 and what it means generally, but what it means in the presidential decrees, like specific things. For example, there's something to do with funding requirements and things like that you will want to follow that's in the presidential decree. Anyway, since more of the details in the presidential decree, I won't go any further into that. This is to specify And just to make clear, unless anybody was confused, that we're not just talking about your own employees anymore in your workplace. We're talking about as top management, as the responsible management party, you're now going to be responsible for anybody on your work site or facility or equipment. That's another thing, the concepts of not just your workplace, facility and place, but also anybody dealing with major equipment has also been included in this concept. Anybody dealing with those things that are providing services to us that might not be our employees, who are providing manpower in exchange for money, those people may also be covered. Okay, so it's a much broader concept than just your employees at your workplace. That is a point of that. So this chart is an easy way for you to look at sort of the differences between SAFA, OSHA, and criminal law in terms of liability. As I mentioned, OSHA generally was intended, even though it covers industrial accidents and it wants to hold responsible people accountable, it generally has been where lower management, as you'll see here, safety and health managers possibly, but someone lower down the chain of command that's generally held responsible under OSHA, as well as for criminal law, right? But under SAFA, again, the point is they're seeing these industrial accidents not as a factor of somebody, again, forgetting to put out a cone or failure to wear a goggle. They're saying it's some structural problem within the organization. And so who can address those structural problems? It's not the people at the bottom. It's the people further up. So like your CEO, okay? So that's why SAFA is important for top management to focus on, because they specifically want to make sure people at the top are held responsible and that those duties can't necessarily be delegated down the chain, okay? And just to mention, at the very top, business owner, that here does not refer to, for example, if you're a corporation, your business owner being the shareholder, it's not referring to that. It's referring to the employer. So if you're not a corporation, for example, if you're a sole proprietor, it would be referring to that person or the company itself, okay? So there is joint and several liability for the company as well as for the individual held responsible. So that's why we wanted to highlight that for the business owner. Okay, so given that I am out of time, I'll just use this one slide in terms of suggested measures. Now that you know that the new law is going into effect, if we work backwards, so if you're a company that has 50 or more employees, as I mentioned, this law will take effect for you starting in January of 2022, right? So working back from that, what you should be doing is a couple of months before it goes into effect, you should be training your executives as well as your employees on the new rules and the new organizational structure and the new procedures that you should be ideally putting in place for what this law is requesting you to do. Okay? But in order for you to be educating and training your employees, you need to go back a couple more months. So somewhere around September or November, you should at least be, having a good understanding of what your potential liabilities are and putting in place. Okay, do we need to reorg or do we need to put in new policies? So have that understanding. But in order to be able to put in right policies and organizational structures, you need to know exactly what kind of liabilities your specific workplaces might foster or might be prone to. And so, in the next month or two, it would be advisable for you to take a broad look at all of your workplaces, okay, and understand what are the kind of accidents that can occur, what kind of illnesses are possible based on your business, based on your working environment, okay? Once you have that foundational information, again, going backwards, then you put in the right organization. Maybe you do need to delegate as the top CEO. Maybe you want to reorganize your organization so that you have a specific department or a specific functional body that will handle health and safety responsibilities. And as the CEO of the organization, that may also, sort of remove you from potential liability if you have a separate body like that. But again, whether that works for your organization or not, whether that's appropriate for your organization or not, will depend on what kind of potential liabilities your workplace poses. Okay, and once you do that, again, last couple of months before the law goes into effect, it would be really advisable for you to educate and train your employees on those new internal policies and organizational structures that you've implemented. That will set you in the most, favorable possible light for you to be able to address any issues that come up because of SAFA. And since I'm running out of time, I will just leave it at that. Okay?
Thank you very much, Elizabeth. A lot of information, a lot of very valuable information, and you know that she's got even more that she could share with you if you have issues or problems. Regarding questions, I think what we'll do in the interest of time, if you look at the bottom of each of your screens, there's a button that you can push to input questions. And so what we would like to do is wait till the end to address any questions that you may have before you forget them. If you have questions regarding Elizabeth's presentation or other things regarding the topics that she addressed, if you could kindly input those questions before you forget them, and then we'll address them at the end as time permits. And to the extent that time doesn't permit, the speakers will obviously have access to those questions so that they can follow up with you. So now, thank you again, Elizabeth. And I'd like to make a brief introduction of our next speaker, Ms. Hyun Kim, who's a partner at Bae Kim & Lee. She also is relatively new to Yulchon, but certainly not new to the legal profession or Korean law or the topics that she'll be addressing today. She is a pro. She started her career actually at Yulchon, but we didn't overlap. I'm at Yulchon now. We didn't overlap. That was a long time ago. And then she spent 18 years at Shin & Kim, and then the most recent couple of years at Bae Kim & Lee. She graduated from Seoul National University with a bachelor's degree, passed the Korean bar back in 2000, got her LLM from New York University in 2005, passed the New York bar in 2007, and of course has been practicing law in Korea for over 20 years. She's a recommended lawyer by the Legal 500, which is a big deal. And she's also been recognized as a leading practitioner by Who's Who Legal 2020. She's got expertise in a broad number of areas within the legal profession, but specifically today, she'll put on her environmental law hat, where she has a great deal of expertise, and she'll talk about legal issues, obviously affecting major developments in the environmental regulations. Excuse me. And also just wanted to mention before I turn the mic over to her, as was mentioned in our flyer, that she also previously served as legal advisor at the Ministry of Environment, which is also very important for the topic that she'll be covering today. So I could spend more time introducing her because she's got just an enormous amount of experience, but I don't want to steal from your time further. So with no further ado, Hyun Kim, the mic is yours. Welcome.
Thank you, Jeremy, for the kind introduction. Hi, I'm Hyun Kim. Hope you find this session helpful for you to navigate through the myriad of the complex Korean environmental regulations. First, I would like to give you a very high-level overview of the Korean environmental regulations, which will be followed by the recent key developments that may have impact on the company's business in Korea. The Ministry of Environment, or MOE, has 74 statutes in total under its jurisdiction as of today. Among these 74 laws, many important legislations were made between 2013 and 2015. I have classified important statutes into 6 categories. First one is climate change and carbon neutrality. Second, waste and resource recycling. And third is regulations on discharge of pollutants of environments such as air, water, and soil, and chemical substances and products related regulations, remedy for environmental damages, and lastly, special law on environmental crimes. Firstly, climate change related laws. Climate change issue seems to return to the political agenda, particularly this year, after the US presidential election in January. Nowadays, especially, it seems everybody in town is talking about ESG, environment, social, and governance in some way or other. As an executive of a company doing business in Korea, you are also probably familiar with the climate change and carbon neutrality issue. Korea introduced its emission trading system in 2015, and carbon price in Korea at this point is the highest among the countries that have emission trading system. Korea's emission trading system is now at its phase 3, and allocation of at least 10% of the total allowances will be made through an auction at a cost starting this year. This means that companies may have to pay money in order to secure its carbon emission allowances, let alone buying the deficiencies from the market. Secondly, waste treatment and the resource recycling issue is becoming more and more important in Korea. We see many private equity firms active in acquiring waste treatment companies because the waste treatment prices in Korea keep soaring. That is because acquiring a new permit for waste treatment business becomes more and more tricky due to so-called NIMBY, not in my backyard phenomenon, the opposition by residents to proposed construction of environmentally obnoxious facilities, such as waste treatment facility in their local area. Thirdly, among the regulations on pollutants discharge, the new Act on Integrated Management of Pollutant Facilities deserves your attention. This new law was enacted in 2017 and applies to large facilities which exceed certain statutory threshold. And the key features of this law is the customization of emission standard for each industry. For example, under the old law, such as Clean Air Preservation Act or Water Environment Preservation Act, the emission standard is the same, regardless of the industry where the facility is operating. This new law allows individualized emission standards in accordance with the best available technology, economically achievable, which is quite long. In short, we call it EAT, for each type of industry. The qualifying companies are obligated to obtain a new integrated permit for each facility by the end of 2024, substituting the current various emission permits, and will be able to negotiate with the regulator the specific conditions of the permit for their facility, including the reasonable period during which they can accommodate the emission level based on so-called BAT. As to chemical substance-related regulations, Korea enacted its version of REACH, i.e. the registration, evaluation, and authorization of chemical substances. It's called REACH in 2015 after the catastrophic humidifier disinfectant accidents, 가습기 살균제 사건, happened in 2011. European Union adopted its REACH back in 2006 in order to provide sufficient information and data on each chemical substance in advance of its market use. The principle of no data, no market of REACH clearly shows its regulatory purpose. The same regulatory purpose serves K-REACH as well. The compliance cost for K-REACH and the Chemical Substance Control Act is quite burdensome. However, given the fact that the sanctions for violation of these chemical regulations are severe, which include criminal punishment of high-ranking officers, securing a compliance system is necessary for operating chemical business in Korea. In addition, MOE conducts occasional market investigation and make criminal referral of level officers, although in many cases, the cases were acquitted by the prosecutor's office in the end. Acts on a remedy for the environmental damage, which related to the reliefs for environmental damage, became effective from 2016 and sets forth a special law for the environmental liability, such as relieving the plaintiff from the burden of proving the causation of harm, the maximum amount of environmental damage as 200 billion Korean won, if the environmental damage are caused without intent or gross negligence, and requires companies operating a pollutant discharging facility which satisfies the statutory threshold to buy environmental liability insurance. And lastly, government may provide aid people suffering from the environmental damages in advance of the civil litigations and seek reimbursement against the company liable for such environmental damages. That was a short summary of some important environmental regulations. Out of these 6 areas, there have been amendment of statutes in 4 areas, which took effect from last year or will take effect from this year. I will cover some of these. First, it's related to climate change legislation. For the climate change regulations in May this year, the Korean government issued its plan for 2050 carbon neutrality and launched the Carbon Neutrality Committee, which is under the direct control of the president. Korea's national target for greenhouse gas reduction is set at 24.4% reduction from the total national GHG emissions in 2017. The Korea initially announced its emission reduction target based on BAU, which is not a concrete number, just a business as usual concept, not a specific historic emission level. However, in December last year, Korean government updated its reduction target based on an absolute target that is more predictable and transparent. Other major countries like US and EU are setting more aggressive reduction target, and Korean government will likely adjust this new target again within this year. This means we will have a stricter regulations in the climate change related regulations. There are 2 important draft bills currently pending at the National Assembly. One is the Framework Act on implementation of decarbonized society to address climate crisis. It's called Green New Deal Framework Act, which lays out the national goal to achieve 2050 carbon neutrality target and sets forth various tools to implement such target. The second one is interesting, the Energy Transition Support Act. The Korean government has a target of increasing the power generation based on renewable sources up to 20% by 2030. And this law provides carrots as well as sticks to coal power plants and the nuclear power plant to reduce the use of fossil fuel. Sticks are the government's authority to revoke a permit for a coal power plant and imposing energy production fees on nuclear power plant and coal power plant. Carrot is providing compensation and or subsidies for nuclear and coal power plant for the voluntary shutdown or energy shift. Again, for the ESG and green finance issue, there was also a major development this year. The amended Environmental Technology and Industry Support Act, which will take effect on October this year, provides 2 major changes. One is to introduce a standard to assess environmental performance of a company to promote environmentally responsible investment. Although everybody seems to be talking about ESG, but nobody knows exactly what it means and how it works. But now we will have a more clear idea on what may constitute environment-friendly investment from the environment issue at least, and the specific standard to quantitatively measure companies' environment-friendly activities. The MOE will provide a specific evaluation criteria tailored to each type of business within the latter part of this year. This standard will apply to public sector as a start and will be provided to financial institutions as a reference model. The other important change is related to the disclosure of environmental information by listed companies. Requiring the disclosure of the information on a company's activities related to environmental protection is an important tool to indirectly enhance the corporate responsibility. MOE proposed to gradually increase the scope of companies who are subject to environmental information disclosure. From 2022, it covers the listed companies whose total assets exceeds 2 trillion Korean won, but from 2025, it will be 500 billion Korean won or more. And finally, in 2030, it will apply to all listed companies. So they are required to register their environmental information in a dedicated portal by the end of June each year. Then the investors can have more access to the environmental information of the listed companies and take this information into account when they decide whether to invest in their company. And for this purpose, MOE and the Financial Services Commission also published green bond guidelines last year. The guidelines set forth procedures for green bond issuance, use of such funds, business evaluation, and all the details about the green bonds. It aims to prevent so-called greenwashing bonds that could be classified as green bond by satisfying certain requirements on paper, but actually do not contribute to improving the environment much. The Financial Services Commission will monitor and prohibit these fake green bonds from flowing out to the market. Secondly, the companies, especially operating facilities which discharge hazardous substances, need to pay a close attention to the amendment of the Act on the Control and Aggravated Punishment of Environmental Offenses. The amendment expands the scope of conduct subject to administrative fines. This act is a special law stipulating more severe punishment for illegal discharge of designated air or water polluting substances and designated hazardous waste. The type of discharge subject to administrative fines are either intentional discharge or discharge of toxic or hazardous substances, or discharge by illegal means, such as manipulating a measuring device or data. It's very rare to have this kind of administrative fine sanction in the environmental law. Usually we have the criminal punishment or the corrective order by the MOE. But the amount of administrative fine under the Act is calculated as the sum of penalty against violation and the cleanup cost. Cleanup cost may be exempted in case of a voluntary cleanup. You need to remember the upper limit of the penalty against the violation is 5% of an average sales amount for the recent 3 years of the place of business where the illegal conduct took place. This is quite a large amount of money, and the amount may be, interestingly, may be reduced if the turnover of the business entity qualifies as a small and medium business, or similar to a cartel leniency program, if you report the violation immediately after and then cooperate with the regulating authority, MOE or local governments, then the amount may be reduced by up to 84%. However, unlike a cartel leniency program, there is no immunity for criminal punishment. So the administrative fine and the criminal penalty may be imposed at the same time. And next amendment is the stricter penalties for against environmental crimes. I will move to the chemical substances related amendment. You can read this after the presentation because we are also already running out of time. So I will move this. I will skip this part. And finally, there's another amendment related to the Waste Control Act. And if your company has a manufacturing facility in Korea and outsources the waste treatment, then you need a system to monitor the compliance of Waste Control Act by your subcontractor, as well as your own company's compliance. Under the amended Waste Control Act, an industry waste discharger, it covers any companies operating discharge or emission facilities, so its coverage is quite large, should confirm the compliance of the applicable provision of Waste Control Act on a monthly basis via an electric information processing system. It's called OLBARO system. And if an industry waste discharger detects any irregularities, suspected or improper waste treatment in the course of the confirmation process, it should be put on the place in your system. It must inspect the waste treatment site and must immediately suspend the commissioning of the waste management if any violation is detected. So you need to pay attention to your subcontractors' compliance of the waste treatment as well. So the key takeaways from my presentation today may be summarized in a few points. First, as you see, there are a lot of amendments and new legislations going on in the environmental regulation sector. So it is important to diagnose your company's compliance and then establish or update the compliance system. The continuous monitoring of regulatory trends and employee training, because it's very detailed and complex, are also recommended. And in particular, following up the latest developments, especially the climate change, ESG, and green finance, will be necessary. For this point, you will see the draft of the so-called K taxonomy within this month, end of June. So you will have a chance to comment on it. So please pay attention to this new legislation as well. Well, because of time, that is all I have for today. So thank you for listening.
Thank you very much, Hannah. That was a very insightful presentation. Thank you. And again, a reminder to everyone that these slides will also be available, so that if you have questions, you can refer to the slides, and then you can also ask follow-up questions. We have a few questions that people have already posted. I think our speakers can probably have access to them. They're in the chat log if you look at the bottom of your screen. The first is a general one, and Pankaj, who is the CEO of a Korean startup here in Korea, a successful one, is wondering, what risks I should be aware of. That's a broad question, right? And there are obviously aspects of both of your presentations that would apply. I remember that, in particular, Hannah just mentioned that in the case of small and medium-sized businesses, they may be eligible for up to an 80% waiver or exemption from certain penalties, right? But in addition to that, I assume there's other things. Anyone want to take a stab at that?
You go first, or should I? Yeah.
You may go
The
first.
second question is for me, so you can go with the first one.
I can.
Oh yeah. I mean, while she's reading that, just from an employment law perspective, I don't know exactly what company you are a startup, CEO of, but just so that you know, under Korean employment labor laws, a lot of penalties apply to, the company and the employer. So, and they're criminal. Unlike in a lot of other jurisdictions where labor and employment laws are not criminal, they are in Korea. So those are obviously risk factors that you should be thinking about, and especially under SAFA that I discussed today, specifically at the top of management. So you being the CEO, you would definitely, be at risk if you had issues of industrial workplace accidents. You want to go ahead and ask?
Yeah, as I explained in my presentation, there are several environmental statutes that punishes the C-level employees, including Chemical Substances Control Act. But I doubt if you do not have any manufacturing facilities using chemical substances, that law will not apply to your company. And in general, Korean startup company, it heavily depends on which industry or which business you are in. But generally, you must be aware of some antitrust laws and environmental laws and labor laws, and those important regulations you should keep in mind. And the second question?
Yeah, the second question.
Go ahead, Jeremy.
Oh, I think you can see it, right? It's from Sachin, our chairman, and it's addressed to Elizabeth. And it talks about, you mentioned manpower and funding requirements are critical as per SAFA. Are these government guidelines clear? And is the government providing support to companies?
Right. So, I mean, I haven't seen anything that specifically mandates a specific, for example, specific number of manpower or specific level of funding. So that's not what it is. So it's really dependent on your operations. What they want to see is that you have procedures in place that properly identify the proper level of funding and the proper level of manpower that you need for your organization to prevent health and safety issues. So it's not like, oh, everybody needs to have, $1 million attributable to safety and health issues. It's, do you have proper procedures and organizations in place that identifies what kind of issues you have and that's properly funded to be able to address those issues. So that's the key. And in terms of, whether the government is providing you with any support, if you're talking about financial support, I haven't seen anything where they're giving you money to give you, safety goggles and whatnot. So not that kind of support, but they're giving you support in the sense of, they have new presidential decrees that will be coming out to supplement the SAFA that we discussed today. And it has a little bit more detail as to what those measures that you need to be taking.
Great, thanks.
Okay, and the next question from Ashutosh, and I think you could see it, is what's the relationship between Chemical Substances Control Act and Serious Accident Punishment Act? Do both laws apply to chemical accidents, or does the Serious Accident Punishment Act override the Chemical Substances Control Act as a special law?
I think I can answer these questions. As Elizabeth mentions, there are industrial accidents and the public accident, which are subject to the SAFA. And chemical accidents could be as qualified as an serious industrial accident under the SAFA. So as far as chemical accidents qualifies as a serious industrial accident under the SAFA will apply as a special law at first, but because SAFA focuses on the punishment of top-ranking officers, the working level officers may as well punished under the Chemical Substances Control Act, because Chemical Substance Control Act does not specifically limit the punishable person as in SAFA. What was the term?
Responsible management party.
Yeah, responsible management party. But it says only any person who caused a chemical accident or responsible for causing the chemical accidents could be punished. I remember its sentencing level of punishment is quite low compared to SAFA. It's like up to 10 years of imprisonment or fine not exceeding 200 million Korean won. So it's compared to SAFA, it's mild, but still some employees could be punishable under the Chemicals Control Act.
And if I could just add to that, I mean, it's really important to note that these laws can go together. It doesn't mean just because, you have one incident, only SAFA or only Chemicals Act or, other OSHA, for example, will apply. It's whatever is applicable, they will all apply. That's what I mentioned very early on, why comparing OSHA with SAFA is important, because they're targeting different levels of responsibility. They will go together. That's why you have the police investigating as well as the labor office investigating, because they're looking for different things. But both laws can apply, even to the same incident.
Right.
Great. Now you'll note that the next question is actually just whether you have the slides available in Korean. I don't know what.
My
Maybe
slide is not.
maybe not, right? Maybe not.
Not right now, at least.
Right. And I guess if there are no other questions, and maybe a few other will arise while I'm asking this, I just was wondering whether there are any, without necessarily sharing the names of the clients, any policies or procedures or best practices regarding controls and training that you might want to share with us, things that we should be doing in-house.
I mean, specifically for SAFA, because it's, so important, at least for the top management, I am seeing a lot of clients focus on, okay, what is it that this law is asking me to do? And as I mentioned, the presidential decree sort of outlines a little bit in more detail what those 4 measures that are in the actual law mean. And so, for example, a lot of companies are doing that first phase. Remember my suggested recommendation? The first phase is have an idea of what your issues are. So a lot of companies are doing that sort of footwork to figure out what those issues are. And then the next stage is to figure out, okay, what kind of organizations or policies that need to change. So I see a lot of companies implementing those in response to SAFA.
Yeah, for the environmental regulations, because these laws are very complicated, you need to have an expert in-house. Usually you have this EHS team in-house, in addition to the legal team. So what we do is to have some training session with the EHS team and help them to establish a compliance system. But it depends on the what kind of industry you are in and how strong is the will of the management.
So you got to figure out the bottom line, what's applicable first, and then you can decide what kind of training or education is required. So we can't, it's not a blanket education or training for everybody. So hard to identify that here.
Thank you. And I think also, for Chi-Hung Chung, your question about the presentation being in Korean, it may not be available right now in Korean, but I think if you would be willing to engage Elizabeth and Hyuna, they could probably do a mini seminar, either as a webinar or visit you in Korean and help provide some training on these things, right?
Yeah, we'd love to. Definitely.
Right. Any other questions? Okay. Well, if any of you think of questions subsequently, we can put you in contact, obviously, with Elizabeth and Hyuna, and they'll also be sharing the presentation materials with all of you. So thank you very much, Elizabeth and Hyuna. I found it fascinating, very interesting, and also scary, as I'm sure many of you did. Hope you all have a good day, and thanks to all of you for participating.
All right.
Thank you very much. Thank
Bye,
you.
everybody.
Bye.
Thanks.
Bye.
Bye.
Thank you. Thank you.
Yeah.